Welcome friends. Today I have a question for you. Which came first, the hen or the egg? Scientists say that probably a near hen-like bird laid an egg that gave birth to a hen. So the egg came first. Probably they are right also. But this question is considered as archetypal of a problem that knows no solution. Now, what is the relevance of this question for us? Any attempt to extend the provisions of the Constitution of India to the state of Jammu and Kashmir without the concurrence of an elected government in Jammu and Kashmir, or an attempt to deoperationalize Article 370 or abrogate Article 370 without the concurrence of the Constituent Assembly of the state of Jammu and Kashmir would face precisely such an insurmountable obstacle. Hence, the measures that were taken by Government of India on August 5, 2019 with respect to deoperationalization of Article 370 is simply not possible within the four walls of the Constitution of India. My concern is not to delve into the wisdom of the measures that were taken, how wise they were or they were not, but to merely analyze the legality of the measures that were taken on August 5. I'll examine whether the measures that were taken were constitutional or not. Again, I'll not analyze the constitutionality from the point of view of the Constitution of Jammu and Kashmir, no. I'll see strictly whether those measures were constitutional as per the Constitution of India or not. So, before we move forward, let's see what Article 370 is and what were the measures that were taken on August 5, briefly. After the independence of India, Jammu and Kashmir was one of the three states to have not acceded to either the dominion of India or the dominion of Pakistan. I'm not going into the fact that whether there was any provision in the India Independence Act 1947 to allow such non-accession or not, even though there's nothing to prevent such occurrence in the plain language of the India Independence Act 1947. But on 22 October 1947, there was tribal incursion supported by Pakistan in the valley of Jammu and Kashmir. The Maharaja of Jammu and Kashmir asked for India's military help. India excused its inability to intervene in Jammu and Kashmir since it was a foreign territory and India could not intervene militarily unless Jammu and Kashmir acceded to India. Faced with the imminent occupation of valley by the tribals, Maharaja of Jammu and Kashmir signed Instrument of Accession on 26 October 1947. The accession was primarily in respect of three major areas: defense, foreign affairs, communication, and certain ancillary areas. But there was one important provision in the Instrument of Accession, that the accession did not in any way meant that the Maharaja of Jammu and Kashmir had accepted the future Constitution of India or the Constitution in any way fettered his discretion. But in any case, within a year, the accession of Jammu and Kashmir was complete for all practical purposes. So much so that the popular leader of the state, Sheikh Abdullah, writes to a Madras weekly Swatantra on the first anniversary of India's independence, celebrating the coming together of the north and the south, the mountains and the oceans, and going even as far as to say that someday when we describe the extent of our country, we shall use the phrase from Kashmir to Cape Comorin, that is from Kashmir to Kanyakumari. But in any case, the relationship between the Union of India and Jammu and Kashmir was amorphous and in the form of instrument of annexation. So the then Prime Minister of India, Jawaharlal Nehru, convinced the popular leader Sheikh Abdullah to integrate the provisions with respect to the relationship between the Union of India and the state of Jammu and Kashmir into the Constitution of India. And thus, Article 370, the then Article 306A of the draft Constitution, was inserted into the Constitution of India. Article 370 makes three broad provisions with respect to union-state relationship in case of Jammu and Kashmir. First, integration of the provisions of instrument of annexation into the Constitution of India. Second, extension of provisions of Indian Constitution additional to those provided for in instrument of annexation to the state of Jammu and Kashmir. And third, to provide for the final nature and structure of relationship between the Union of India and the state of Jammu and Kashmir to be decided by the Constituent Assembly of the Jammu and Kashmir. The first provision, that is the integration of the provisions of the instrument of annexation into the Constitution of India, is provided for in Article 370, Clause 1, Subclause C, which says that Article 1 and Article 370 shall only apply to the state of Jammu and Kashmir. Now, what application of Article 1 does is to provide a gateway for Jammu and Kashmir to be integrated into the Union of India, because Article 1 provides for India being a union of states and the territory of India. So to have demanded the dissolution of Article 370 is very naive and foolish, because Article 370 itself says that Article 1 applies to the state of Jammu and Kashmir. Other than this, instrument of annexation specifies areas with respect to which Union of India can exercise jurisdiction over the state of Jammu and Kashmir. So Article 370, Clause 1, Subclause B, Paragraph 1 basically provides for the matters in the concurrent and the union list to be specified by the President for authorizing the Parliament to legislate on those matters. Now, this authorization and this specification by the President has to be done with the consultation of the government of Jammu and Kashmir. Here, only consultation is required and no consent is required. Now, coming to the second major provision with respect to extension of additional provisions of the Constitution of India than what was specified in the instrument of annexation to the state of Jammu and Kashmir. Now, additional provisions of the Constitution of India, other than Article 1 and Article 370, as well as authorization of Parliament to legislate on matters other than those specified in the instrument of annexation, can happen only with the concurrence of the government of the state of Jammu and Kashmir. Here, the consent of the government of Jammu and Kashmir is necessary. Which brings us to the elephant in the room. What do we mean by government of Jammu and Kashmir? Initially, government meant Maharaja acting on the advice of Council of Ministers. Subsequently, through a Constituent Assembly of Jammu and Kashmir's resolution dated 19 August, which was notified by the President of India through a constitution order on 15th November, the government was to mean Sadr-e Riyasat acting on the advice of the Council of Ministers. There was one further amendment in 1965 through Constitution application to Jammu and Kashmir, Second Amendment Order, whereby now the government was to mean governor acting on the aid and advice of the Council of Ministers. But since 1952 Constituent Assembly resolution and the notification by the President of India, one principle has remained constant, that the government was essentially representative in character, was republican in nature, which has not been interfered even in the judgment of the Honorable the Supreme Court of India with respect to this particular aspect in Muhammad Maqbool Damnu, as we shall see later on. The third major provision in Article 370 is to provide for the fact that the final shape and contours of the relationship between the Union of India and the state of Jammu and Kashmir was to be determined by the Constituent Assembly of the state of Jammu and Kashmir. This was nothing but the fulfillment of the promise of Government of India at the time of signing of the agreement, in the subsequent negotiations, as well as what was specifically said by Iyengar in detailed exposition of Article 370 on October 17, 1949 in Constituent Assembly. He said that the people of the state of Jammu and Kashmir shall determine the constitution of Jammu and Kashmir as well as the sphere of union jurisdiction over the state of Jammu and Kashmir. So, the final shape of union-state relationship was to be determined by the Constituent Assembly of Jammu and Kashmir. Hence, two major provisions in this respect was made in Article 370. Article 370 Clause 2, Article 370 Clause 3. Article 370 Clause 2 says that if any additional application of the provisions of Constitution of India, additional to the instrument of accession, is done to the state of Jammu and Kashmir before the Constituent Assembly starts its functioning, the same has to be ratified by the Constituent Assembly so as not to fetter the Constituent Assembly in any way. Now, after the final shape has been given to the union-state relationship by the Constituent Assembly, there may be a need for change in Article 370. So Article 370 Clause 3 provides for that eventuality. It says that the President may declare that Article 370 has ceased to exist or shall continue to function with such exceptions or modifications as he may specify on the recommendation of the Constituent Assembly of Jammu and Kashmir. So the temporariness of Article 370 was not with respect to any timeline, 10 years, 15 years, 20 years, as was in case of certain articles, say Article 343 with respect to official languages. The temporariness of Article 370 meant that the nature of union-state relationship with respect to Jammu and Kashmir was temporarily provided for in Article 370 till the point it is finally decided by the Constituent Assembly of the state of Jammu and Kashmir. Even this has been specifically averred by Iyengar in his exposition of Article 370 in the Constituent Assembly on the same date, 17 October 1949. He says that when the Constituent Assembly has met and has decided the constitution of the state of Jammu and Kashmir and the range of federal jurisdiction over the state of Jammu and Kashmir, President, on the recommendation of the Constituent Assembly of Jammu and Kashmir, shall declare that the Article 370 ceases to exist or continues to operate with such exceptions or modifications as he may specify, which is what finds its way in Article 370, Clause 3. This view has been ratified by the Honorable the Supreme Court of India in a catena of judgments. In Sampath Prakash versus State of Jammu and Kashmir, the Honorable Court, when faced with the argument that the Article 370 has actually ceased to operate after the secession of the Constituent Assembly of the State of Jammu and Kashmir, said that there are weightier arguments in favor of continuance of the operation of Article 370. The court says that it appears that the Constituent Assembly intended the Article 370 to continue operating with only one modification dated August 19, 1952, when Maharaja was amended to Sadr-e-Riyasat. That is the only modification that was made in the body of Article 370. Further, the judgment of the Honorable Supreme Court in the SBI versus Santosh Gupta in 2016, the Honorable Court observes that since Constituent Assembly of the Jammu and Kashmir has ceased to function, there is no way it can recommend cessation of Article 370. Hence, Article 370 is permanent in nature. The Honorable Supreme Court reiterated this stance while hearing a petition by Kumari Vijayalakshmi Jha, when it observed on April 3, 2018 that Article 370 is permanent in nature. So not only the plain word of the Article 370, but its interpretation in objective as well as contextual manner, as well as the subsequent judgments of the Honorable Supreme Court, clearly indicates it's permanent in nature. On August 5, 2019, President of India passed one order for application of the Constitution to the state of Jammu and Kashmir. Then Parliament of India passed two resolutions, one with respect to deoperationalization of Article 370 and the second with respect to reorganization of the state of Jammu and Kashmir. Then one bill was introduced for the purpose of reorganization of the state of Jammu and Kashmir in Rajya Sabha, which was passed therein on the same day, and in Lok Sabha on the next day. Since we are dealing with Article 370, we are concerned only with the order of the President and the first resolution passed in the Parliament. Now, the order of the President basically applies the whole of the Constitution of India to the state of Jammu and Kashmir in supersession of 1954 presidential order applying the Constitution of India to the state of Jammu and Kashmir as amended from time to time. Now, this presidential order of 2019 applied the Constitution of India with one slight modification in Article 367, adding Clause 4. Now, what did this application fundamentally change? Even by the order of 1954 as amended from time to time, almost over 80% of the Constitution of India had already been applied to the state of Jammu and Kashmir. In case of the provisions of the Constitution of India that were not applied to the state of Jammu and Kashmir, for example, provisions in regard to the government of the state, the Constitution of Jammu and Kashmir made provisions broadly on the lines of the Constitution of India. So, practically almost the whole of the Constitution of India was already applied in the state of Jammu and Kashmir. But among others, there was one major change that happened due to supersession of 1954 order, and that was the abrogation of Article 35A of the modified Indian Constitution in its application to Jammu and Kashmir. Now, this article provided for certain special provisions for the permanent resident of the state of Jammu and Kashmir, including the most popular provision of the property rights. Besides, 367 clause 4 in its modified form already had 3 of the 4 provisions that were instituted by this presidential order of 2019. One provision that was added was for the Constituent Assembly in Article 370 clause 3 to mean the Legislative Assembly of the state of Jammu and Kashmir. Now we know that any provision of the Constitution of India additional to those mentioned in the instrument of accession, if applied to the state of Jammu and Kashmir, requires the concurrence of the government of Jammu and Kashmir. So the major question in this presidential order would be whether the concurrence of the Jammu and Kashmir government has been obtained. In this relation only, one question would be whether the application of Article 356, that is the President's rule, in Jammu and Kashmir ipso facto provides such a concurrence. Now moving on to the resolution passed in the Parliament, the first resolution. This resolution states that all the provisions of Article 370 ceases to operate except a new provision in the form of Article 370 clause 1, which states that all the provisions of Constitution of India as it is shall apply to the state of Jammu and Kashmir. Now again we know that for the dissolution of Article 370 or deoperationalization of Article 370, recommendation of the Constituent Assembly of the state of Jammu and Kashmir as per Article 370 clause 3 was required. Now how did the President obtain it? We have already seen that in the just passed presidential order, there was a provision in Article 367 clause 4 subclause D for the Constituent Assembly of the Jammu and Kashmir in Article 370 clause 3 to mean Legislative Assembly of the state of Jammu and Kashmir. Now there was already President's rule imposed in the state of Jammu and Kashmir under Article 356 dated December 19, 2018, by which order reference to Legislative Assembly of the state of Jammu and Kashmir was to mean reference to Parliament of India. So, by the presidential order of 2019, Constituent Assembly was to mean Legislative Assembly of the state of Jammu and Kashmir, and by the earlier President's rule, the Legislative Assembly of the Jammu and Kashmir was to mean the Parliament of India. So, the Constituent Assembly was taken to mean the Parliament of India, and thus it was taken to mean that the Parliament of India could recommend cessation, abrogation, modification, etc. of the Article 370 of the Constitution of India. So the question that would arise is whether such an interpretation is allowed, or whether such an interpretation is not an amendment of Article 370 itself through back door. So now let's move forward to see whether these steps and the measures that were taken August 5, 2019 are constitutional and legal or not? Now let us come to constitutional challenge to the Presidential Order of August 5, 2019. The Presidential Order says that it was passed with concurrence of the Government of State of the Jammu and Kashmir. Now, to understand whether the concurrence was obtained or not, let us understand the meaning of Government of Jammu and Kashmir. In the beginning, Government of Jammu and Kashmir meant Maharaja of Jammu and Kashmir acting on the advice of Council of Ministers in the state of Jammu and Kashmir. Now, on a resolution of the Constituent Assembly of Jammu and Kashmir, this was changed to an elected Sadr-e Riyasat in 1952, August 19. The same was notified by the President on November 15, 1952. So, this was a duly enacted amendment in Article 370 because it was done by the President on the recommendation of the Constituent Assembly of the state of Jammu and Kashmir. The second change was done when the Constitution of Jammu and Kashmir was amended by the Legislative Assembly of the Jammu and Kashmir in 1965. By the 6th Amendment to the Constitution of Jammu and Kashmir, Sadr-e Riyasat was changed to Governor. Now, in pursuance thereof, in 1965, President of India notified a modified application of the Constitution of India, whereby in the interpretation clause 367 subclause 4, clause AA and B, relevant changes were made. In the subclause B, the government of the state of Jammu and Kashmir was taken to mean the governor acting on the advice of Council of Ministers. Now, this was challenged by the petitioners in Mohammad Maqbool Dar versus the state of Jammu and Kashmir before a 5-judge bench in the Supreme Court of India. The contention of petition was that 370 has been amended through backdoor of Article 367. Article 370 could be amended only under Article 370 clause 3 or arguably under Article 368 of the Constitution of India, though itself it would be subject to judicial review, but none was done. The Constitution bench of the Honorable Supreme Court observed that it is no amendment of Article 370 through backdoor, since the explanation to clause 1 had become OTOs, that is outdated, because 6th Amendment to the Constitution of Jammu and Kashmir had replaced Sadr-e Riyasat with the governor. So, concomitant changes was required in the explanation. It is not an amendment, it is merely an interpretation. The Constitution bench in paragraph 28 specifically observes that in wake of the 6th Amendment of the Jammu and Kashmir Constitution, either the explanation should have been clarified in some definition clause or it would have been given some interpretation by the Supreme Court of India. So it has been clarified through Article 367 clause 4. Now, through these changes, one thing has remained constant since 1952, that is the government of the state of Jammu and Kashmir has been taken to mean the elected representative government of the state of Jammu and Kashmir. Now, the presidential order says that the order has been passed with the concurrence of the government of the state of Jammu and Kashmir. But after the imposition of Article 356 on December 19, 2018, there is no government of Jammu and Kashmir per se in the state. The power has been transferred to the union government. Now the question that arises is, has the power under Article 370 Clause 1 been also transferred to the union government? For answering this, we'll have to understand the nature of power that resides in Article 370 as well as the provisions in Article 356. Article 370 provides for the constitutional law of the state of Jammu and Kashmir, which was nothing but Constitution of India and its application to the state of Jammu and Kashmir, as well as the Constitution of Jammu and Kashmir. Now, since there was possibility of change in the nature of union-state relationship with respect to the state of Jammu and Kashmir, depending on the final decision of the Constituent Assembly of Jammu and Kashmir, as well as varying circumstances, there was provision made with respect to the changing application of the Constitution of India with respect to the state of Jammu and Kashmir under Article 370 Clause 1. Now, since the provision in Article 370 Clause 1 was with respect to application of the Constitution of India on the order of President in consultation with or concurrence with the government of the state of Jammu and Kashmir, the power was constituent in nature. And it is a well-established principle of law that the constituent power has to be exercised by the very body in which it inheres and in exactly the prescribed manner. The constituent power and the provisions thereof has to be interpreted in the strictest possible manner. Why? Because constituent power is the fountainhead from which all other powers emanate. The unity, integrity, and the order of the state depends on the constituent power and its effective exercise. So, in no circumstances can the constituent power be transferred to any body other than clearly and explicitly mentioned and delineated in the Constitution of India. Hence, this power, which is to be exercised by the President with the concurrence of the government of Jammu and Kashmir, meaning governor acting on the advice of Council of Ministers, and since there is no Council of Ministers, since there is no government in the state of Jammu and Kashmir, this power cannot be exercised and is void ab initio. It is ultra vires the Constitution of India. Assuming that there is provision for such transference of power. Now let's see what Article 356 says. Article 356 Clause 1 subclause A provides for transference of executive power. It says that the powers vested in the governor and other authority other than legislative authority shall stand transferred to the President. Subclause B says that the legislative power shall be transferred to the Parliament, not to the President. Now, Parliament under Article 357 may delegate this power to President or any authority under him. That's a different aspect. But the power directly does not get transferred to the President. So, if the legislative power cannot be transferred, how can the constituent power be transferred to the President? That is another major challenge under Article 356 itself. Now let's proceed and see what the purpose of Article 356 is. Clause 1 says, in case the government of the state cannot be carried on in accordance with the provisions of the Constitution, President rule can be imposed. Now, the object of the imposition of Article 356 in any state is to enable carrying out of the government of the state in accordance with the provisions of the Constitution. Now, Constitution in its application to Jammu and Kashmir is the Constitution of India as applied through various presidential orders, as well as the Constitution of Jammu and Kashmir. So, to say that the authority under the constitutional law surpasses the constitutional law and changes the very constitutional law under which it has assumed power in Article 356 is beyond constitutional imagination and the provisions of the Constitution. Now, if such transference of power is not allowed and the presidential order of 2019 is not allowed, then the subsequent resolution in the parliament cannot be passed and 370 cannot be abrogated. Now, if the order of the president dated August 5, 2019 cannot be passed, Constituent Assembly cannot mean Legislative Assembly, and hence Article 370 cannot be abrogated. For abrogation of Article 370, concurrence of the government of the state under Article 370 clause 1 itself is required. It's a circular provision, and hence any attempt to abrogate Article 370 is faced with egg and hen like situation, a catch-22 situation, which makes it almost impossible to amend Article 370. And that's why I said what I said. Now let's proceed and analyze this whole situation on a much more fundamental and intuitive level. Here, two authorities, Authority A and Authority B, Authority A being the President of India, Authority B being the government of the state of Jammu and Kashmir, is involved. Authority A has to pass an order in concurrence with Authority B. Now, independent of this, Authority A has been provided with other powers, Authority B has been provided with other powers. See, the transference of other powers from Authority B to Authority A is possible, but the power of concurrence is by its very nature not possible, because views of B cannot be transferred to views of A. Views of B remains with him only, by its very nature. Hence, the power of concurrence by its very nature cannot be transferred from one authority to another authority, even though other powers can be transferred. Now, let's proceed a step further. Let's assume that the concurrence was given by governor on the advice of Council of Ministers. Then will it be possible to pass presidential order of August 5, 2019? Government of Jammu and Kashmir functions under its own relevant constitutional law, that is the Constitution of India in its application to Jammu and Kashmir, as well as the Constitution of Jammu and Kashmir. Now, application of the provisions of Constitution of India beyond what is mentioned in the Constitution of Jammu and Kashmir has no limitation, no bar. But to interfere with the provisions of Constitution of Jammu and Kashmir would be violation not only of the provisions of Jammu and Kashmir, but the provisions of Article 370 of the Constitution of India also, because the Constitution of Jammu and Kashmir has been framed by the provisions of the Constitution of India, that is the Article 370. So, to enable any order which interferes with the provisions of the Constitution of Jammu and Kashmir without relevant changes and amendments in the Constitution of Jammu and Kashmir itself would be in contravention of both the Constitution of Jammu and Kashmir and Constitution of India. So even when such a plenary order as dated August 5, 2019, which applies all the provisions of Constitution of India in supersession of the provisions of Constitution of Jammu and Kashmir also, is in contravention of the Constitution of India and hence is void. Now let us look at the constitutional validity of the resolution of Parliament acting as the Constituent Assembly of the state of Jammu and Kashmir, passed on 5th August 2019. Parliament could function as Constituent Assembly since on the very same day earlier, President had issued an order wherein there was one provision which interpreted the Constituent Assembly of the state of Jammu and Kashmir in Article 370 Clause 3 Proviso to mean the Legislative Assembly of the state of Jammu and Kashmir, and that Legislative Assembly, through the imposition of Article 356 President Rule, had become Parliament. Assuming the presidential order to be valid from the point of view of procedure, is such an interpretation of Constituent Assembly to mean Legislative Assembly of the state of Jammu and Kashmir valid? Now, interpretations function where there is gap in the understanding of the provision of the Constitution, or the provision is widely worded, vague, or had become OTOs, that is stale and meaningless. But with the proviso to clause 3 article 370 explicitly mentioning Constituent Assembly, the interpretation through 367 would be challenged on the basis that it is an amendment of Article 370 through backdoor. Now, as we have seen that Article 370 can be validly amended only by an order of President on the recommendation of the Constituent Assembly under Clause 3 Article 370, or arguably under Article 368, since Article 370 is a provision of the Constitution of India, though the latter method will face a stiff constitutional challenge. But the presidential order of August 5, 2019 used none of these methods. Hence, if it is an amendment through the back door, it is invalid and void ab initio. But there may be one logic and rationale behind this amendment, that since the marginal law to Article 370 mentions that it is a temporary article, and since for dissolution of Article 370 Constituent Assembly is required, and Constituent Assembly had ceased functioning in 1957, some interpretation had to be given, which brings us to the temporariness of Article 370. Now, there is nothing in Article 370 which says that it should be compulsorily abolished after a certain point of time. Clause 3 of Article 370 itself gives clue to the nature of temporariness of the Article 370. It says that this article should cease to operate or should operate with such modifications, exceptions as President may declare on the recommendation of the Constituent Assembly of the state of Jammu and Kashmir. So the temporariness was in the context of the Constituent Assembly of the state of Jammu and Kashmir finally delineating the nature and the contours of union-state relationship with respect to Jammu and Kashmir, as we have already seen. The same was iterated by Iyengar on 17 October 1949 in Constituent Assembly in exposition of Article 370, and further buttressed by the Honorable Supreme Court in its various judgments, Sampat Prakash versus State of Jammu and Kashmir, SBI versus Santosh Gupta 2016, and in other instances. So for all practical purposes, Article 370 was permanent. So this argument that Article 370 was temporary and needed to be dissolved and hence Constituent Assembly was required, holds no water. Was Constituent Assembly required for any other purposes so that proviso to clause 3, article 370 would become otiose in its absence? Now again, as we have seen that the provisions in clause 3, article 370 debates in the Constituent Assembly as well as various judgments of the Supreme Court intended Constituent Assembly only for the purpose of finalization of nature-state relationship with respect to Jammu and Kashmir. It was not required once it had finalized the relationship. Now at the expiry of Constituent Assembly of Jammu and Kashmir in 1957, constitutional law for the purpose of the state of Jammu and Kashmir, as we have already seen, was Constitution of India in its application to Jammu and Kashmir as well as the Constitution of Jammu and Kashmir. So once that purpose had been resolved, the nature of relationship was finalized and Constituent Assembly was required no more. Also, Article 370 had become permanent. Now this permanent relationship should exist within the provisions of Article 370, or the 370 should have been abolished entirely and some other article, say 396, 396A, or any other article for that matter, should have been instituted, is a debate based on form and not the substance. Now moving further, suppose Constituent Assembly was required in some eventuality. Is there any bar to reconstitution of Constituent Assembly in the case of Jammu and Kashmir? No. So if at all Constituent Assembly would have been required, there is no bar to its reconstitution. Hence proviso to clause 3, article 370 had not become otiose and needed no interpretation. Thus, the reinterpretation of the Constituent Assembly in the proviso as the Legislative Assembly of the state of Jammu and Kashmir is an amendment for all practical purposes and is void as being in contravention with the provisions of the Constitution of India. Now let's move to a much more fundamental level. Constituent Assembly of a nation or a state is brought into existence to create a legal framework for a nation state or the society therein. People elect the members of a Constituent Assembly consciously for that purpose. Now a Legislative Assembly which is elected by people for the purpose of functioning under the existing constitution as framed by the Constituent Assembly cannot surpass its jurisdiction to function as Constituent Assembly, through the work of which, that is through the constitution made by it, it derives its power. So for the Legislative Assembly, which is elected to function within the existing constitution, to mean Constituent Assembly is a challenge to the notion of popular sovereignty as well as the very idea of constitutionalism. And hence, no such interpretation is possible. So the order of President and the resolution of Parliament face an almost insurmountable barrier in the face of various constitutional difficulties. But since the petitions are yet pending in the Honorable the Supreme Court of India, let's see what follows. Thank you so much. Have a great day.